All right, ladies and gentlemen, it's my understanding that you have reached a verdict on all 10 counts. Is that correct?
In Morton County, North Dakota, a chiropractor is accused in a quadruple homicide. Today, the widow of one of the victims testifies.
I saw Robert, people trying to resuscitate Robert.
What was your immediate reaction when you saw Robert?
I believe I let out a scream.
On the docket tonight in Atlanta, Georgia, Rayshard Brooks shot and killed by police after stealing their taser and firing towards Officer Garrett Rolfe. Tonight, we have a preview of the officer's trial.
The possible sentences for a felony murder conviction would be life without parole, or the death penalty.
In tonight's unsolved case file, in Poway, California, Nikki Benedict, brutally murdered in 1967, stabbed while walking home. Now, 54 years later, her sister, still looking for justice, joins us live.
Imagine spending your lifetime dealing with this kind of violent murder that makes no sense. There's no motive. Imagine living your life like that. You would want to know.
In Lincoln County, Colorado, newly released body camera footage shows a deputy being ambushed during a burglary call. We have the video.
Hey, where you hit? Where you hit? I got you. Where you hit? I'm right here, Mike. Where? We're here.
In Richmond, Kentucky, police negotiating with a suspect after a couple is shot and killed in an apartment building set on fire. Our law enforcement experts break it down during crime time.
Our community is saddened because Mr. and Miss Hager are pillars of our community. A lot of people knew them. A lot of people had contact with them.
Plus, Robert Durst's highly anticipated testimony is on hold until next week. Do you think his testimony will help or hurt his case? Go to our Facebook pages and tell us what you think. Good evening to you and welcome to Closing Arguments. I'm Julie Grant, in tonight for Vinnie Politan. We begin this evening with breaking news out of Idaho, where court filings are revealing that prosecutors will seek the death penalty against the so-called doomsday prophet Chad Daybell. Chad and his wife, Lori Vallow Daybell, are accused in multiple homicides. They're accused of murdering Lori's two children, 16-year-old Tylee Ryan and 7-year-old J.J. Vallow, and Chad's first wife, Tammy Daybell. Now, in the court document just filed today, prosecutors say that they will seek the death penalty against Chad Daybell if he is convicted on any of the 3 first-degree murder counts, as well as any of the counts of conspiracy to commit first-degree murder. Chad Daybell has a pretrial conference scheduled for September 30th, and his trial date is currently set for November of this year. Now, Lori's case is still on pause right now for competency reasons, but remember, that can change. We want to move on now to our other big stories of the day. This afternoon in Tennessee, the jury rendered a guilty verdict in the capital case against defendant Steven Wiggins. Wiggins is the man who murdered a police sergeant and then set his patrol car on fire. This is him walking into court there with the beard and the glasses. Let's take a look back together at the moment the jury's decision was read.
Right. As to count 1 of the indictment, the charge of false report, can you tell me how does the jury find?
Guilty, Your Honor.
As to count 2, premeditated first-degree murder, how does the jury find?
Guilty, Your Honor.
As to felony murder, first-degree murder, felony murder on count 3, how does the jury find?
Guilty, Your Honor.
As to count 4, theft of property, how does the jury find?
Guilty, Your Honor.
As to count 5, theft of property, how does the jury find?
Guilty, Your Honor.
As to count 6, criminal impersonation, how does the jury find?
Guilty, Your Honor.
And as to count 7, criminal impersonation, how does the jury find?
Guilty, Your Honor.
Count 8, tampering with evidence, how does the jury find?
Guilty, Your Honor.
And count 9, arson, how does the jury find?
Guilty, Your Honor.
And count 10, abuse of the corpse, how does the jury find?
Guilty, Your Honor.
Thank you. Ladies and gentlemen, Is this the unanimous verdict of all 12 of you who decided this case? May you affirm by raising your hand. All right, let the record reflect all 12 jurors have affirmed the verdict. As the 13th juror, this court affirms that verdict as well.
Now, the jury will return on Saturday for the penalty phase in this case. They are sequestered, remember that, brought in from another county. There's what's called a change of veneer happening in this one. Let's bring in our think tank now to react to the verdict. Joining us tonight from New York, criminal defense attorney Renee Hill, and from Atlanta, Georgia, criminal defense attorneys Michael Bixon and Eklund Mercy. It is wonderful to see you all tonight. Thank you so much for being on Closing Arguments. I just want to go around quickly and get your reactions to this verdict. Renee, I will begin with you, please.
Well, I'm not surprised, and it was a particularly heinous crime, as many of the trials are that we have here on Court TV. And I'm not surprised that the jury returned the verdict that they did. You know, this is the one thing or the major thing that officers are quite concerned about every day when they go out, is whether or not they're going to make it back home. And traffic stops are extremely dangerous for them.
You're absolutely right, Renee. Well said. Eklund, I want to go to you next for reaction, please.
Yeah, well, I wasn't surprised or shocked, as Ms. Hill stated, at the guilty verdict. I just hope that this sheds a light to law enforcement, that the actual, the potential for harm doesn't come from a Black person. It can actually come from a middle-aged white man. This crime was just insanely heinous and insanely traumatic. I believe even the agent that was on the scene will have nightmares from it. So although I'm not surprised by the guilty charges, I'm actually surprised at just how heinous it was to a law enforcement officer.
Eklund, excellent points. And last but certainly not least, Michael Bixon, I want to go to you next, please.
Yeah, I mean, as previously stated, this is not much of a shock. I think we all knew what the verdict was going to be in this case. The question what comes next, and whether or not they're actually going to give him the death penalty. I mean, this is a particularly heinous and brutal killing. I mean, when you look at all the facts of it, the number of shots fired, the way that they were shot, and the statements that he made after, it's just really, really bad. So the verdict wasn't much of a surprise, but I think the big question is what comes next.
Yes, great point. And we're going to know as soon as this all begins on Saturday, as it begins on Saturday. What we want to look back now on today is some really important moments that occurred. One of which today was with the rebuttal argument. This one made by prosecutor Ray Crouch on the case. Very compelling arguments before the jury went back to deliberate. We want to share some of that with you again now.
That's an execution. There were no chest compressions. That's an acting job. He was trying to play up again to Agent Neese in that interview. No tears. No tears from Agent Neese. Those are self-serving statements. Oh, I did 8 to 10 chest compressions. No. He walked up, and according to the medical examiner, 2.5 to 3 feet, bam, bam. That is an execution.
Once I realized there wasn't no saving him, I backed up. I think I was on his side. And I just wanted to close my eyes and pull the trigger. I think it might have been twice. Just...
Why'd you do that?
I don't know. I guess from that point on, I realized how bad it was. You know, it's like a dog. You don't let it suffer. You make sure, you know.
Reflection and judgment. He acknowledges that. I realize. Think about that word, realize. That's reflection and judgment. Acknowledging. Think about what the defendant, in his own words, is saying. Put him down like a dog? Like he's taking an animal to be euthanized? What more reflection and judgment can be demonstrated?
Renee, I want to bring in you on this one. You know, I thought it was brilliant that he played back the defendant's own words. And to me, hearing those words about comparing this sergeant, this hero, to a suffering dog, to me, that was one of the most disgusting things in this case. And I want to get your take on the advocacy, what you thought of that prosecutor using the defendant's own words in those final moments before the jury gets this case to decide his fate.
I thought it was extremely powerful, and he did an excellent job. He used the evidence that he had, and he used it the way he was supposed to use it. I've done that in trials before where I've had the opportunity to have something that's recorded from a witness and played it back and used, different testimony, even when you've impeached a witness and you have it in the transcripts and you read it back to the jury, you point it out and show it to them. It is extremely powerful. And he did an excellent job here.
I'm with you on that one. And where this defendant is saying that, like, as if he's doing him a favor. I mean, he just took this man's life, deprived his wife of a spouse, his daughter of a father, all of that, and then he acts like he's the hero and I'm going to put him out of his misery and shoot him a couple more times. Just despicable, and clearly the jury they weren't buying it. I want to play another clip where Steven Wiggins decides not to testify today because some of us watching wondered if he would, being that his defense team said that premeditation was the issue they were really focusing on. Let's take a look back together at that moment now.
Mr. Wiggins, have I, along with Mr. Simmons and Mr. Hopkins, fully explained to you your right, absolute right, to testify on your own behalf in this trial?
Yes, sir.
Likewise, have the three of us also fully explained to you your right not to have to testify, to ever have to testify in this trial?
Yes, sir.
And do you understand those rights?
Yes, sir.
And understanding those rights and having talked about that, is it your desire today not to testify on your own behalf?
Yes, sir.
Thank you, Your
All
Honor.
right, Mr. Wiggins, my job is to make sure that you are making a knowing and voluntary waiver of your right to testify. Do you understand that if you want to testify on your own behalf at this trial, that you have that absolute right and no one can stop you from doing so?
Yes, sir.
But likewise, do you understand that if you choose not to testify, no one can make you testify? Do you understand that?
Yes, sir.
And do you understand that if you choose not to testify, that the court will instruct the jury that they are to have no inference that arises from your refusal or declining to testify at your own trial?
Yes, sir.
Is this a decision that you've discussed with your lawyers?
Yes, sir.
And is this a voluntary and intelligent and knowing decision on your part?
Yes, sir.
All right. Now, I found that he has knowingly and intelligently waived his right to testify in the case. So.
Thank you, Your Honor.
So that was his decision. Eklund, I want to go to you on this one, please. What do you think about that? Do you think there was any way this guy could have possibly helped himself by testifying?
Oh, God, no. Oh, God, no. Not in any way, shape, or form. This was the best decision for him. Even with the questions about whether he's going to testify, he wants to leave. I don't think he would last 5 questions on cross-examination. I think it was the best decision for him not to testify. And again, what you don't want to do is, because we have the recording, and the recording is the crux of the prosecution's case, they can easily compare that to whatever testimony he provides. So this was probably the best thing for him. You know, it leaves stuff for appeal, but yeah, he should not have testified in this case.
Right. I'm with you there, Eklund. Smart move. Don't think he would have helped himself on that one. Eklund Mercy, Renee Hill, Michael Bixon. It is a pleasure to have you three on the program tonight. We're going to be talking a lot more. Our think tank's going to stay with me. Want you to stay with me too at home, please. We just have to take a quick break right now. When we return, we're going to turn our attention to a quadruple homicide case. We're bringing you live here on Court TV. This one is out of North Dakota. We'll have a live report with the very latest for you next.
When did you learn that Robert was having an affair?
April 30th, April 30th, 2019, sorry.
Why do you remember that specific date?
Because it was the second worst day of my life.
When was the first worst day of your life?
April 1st.
Who told you about that affair?
Patton. Detective Patton, Detective Joe.
Were those some of the investigators in this case?
Yes.
That was the widow of one of the 4 victims who was killed in the April 1st, 2019 massacre at RJR Maintenance and Management. Defendant Chad Isaak, a chiropractor and a veteran, is the accused on trial. Now, today, the jury heard some very emotional testimony from the grieving widow about the death of her husband and the alleged affair that he was having before his death. Now, something that Isaac's defense team brought up during cross-examination in an effort to possibly point the finger at her. Let's take a listen together now.
We talked about your interview on April 30th with BCI Agent Arenz and Lieutenant Pat Howe, correct? When they basically told you about Robert's affair?
Yes.
And they told you they had discovered this on his phone?
Yes.
Correct? And then they also confronted you with comments you had made in the presence of an employee, a former employee now by the name of Michelle.
Yes.
And I think the question that was asked of you was whether or not you ever made a threat to kill him.
No.
The question that was asked of you, that there would never be a divorce from Robert, that you would have him taken care of. Did you make that statement?
No.
Do you want to look at the transcript to refresh your recollection?
No, I don't need to. I know I didn't say that.
You didn't say it in the transcript?
I did not say I would ever have Robert taken care of, no.
They asked you specifically if you would have said the phrase that you would have him taken care of, and then you said 3 times on the next page, I probably would have said that. Yes, I've said that. I will admit to saying that.
I don't remember saying that. If that was ever said, it would have been a joke, but no, I don't recall saying not 3 times that yes, I did, and definitely I did. No, I don't recall that.
So then prosecutors followed up on those alleged statements on redirect of the witness. Let's take a look.
Do you remember making any threats against Robert's life prior to his death?
No, I don't.
Okay.
I really don't.
When those documents were brought up to you, what were those documents about?
About me stating that.
So were those documents that were brought up to you a transcript of your conversation and interview with law enforcement?
To my knowledge, that's what it is.
Okay. So when you read through those documents, could you see questions posed by law enforcement and then your responses?
The only thing that caught me is I did kind of chuckle because as a joke with Robert and I, we would say, I might have said it to Robert directly as a joke, but I would have never threatened Robert's life to anyone.
Okay. So when you were looking at those documents, you could see that response that you remember and recall giving to law enforcement.
And that's very possible. Very possible.
Okay.
I just don't remember.
So again, had you said that statement, which you don't recall making, would it have been intentional?
I don't know. I don't know my mindset. You have to remember that day I was told my husband had an affair. Okay, my mind was not straight at all. And I was very angry. So I couldn't tell you. I can answer you correctly about that day.
But on the day that you were asked, had you ever made these statements before? Had you recalled ever making those statements?
Not to my knowledge. I do not I'm pretty sure I never made those statements.
I want to bring in now live Court TV legal correspondent Chanley Painter. She's joining us tonight from Mandan, North Dakota with the latest on what's happened today in the case. Chanley, good evening.
Hey, good evening, Julie. Yes, the Testimony of the widow of Robert Faulkner was the biggest moment inside this courtroom today. Her emotion, the prosecution using her for many purposes, really to bring all four of the victims to life inside the courtroom for the jury, but also to talk more about the RJR maintenance and management business and how the day of the murders changed the business forever. But as you said, the defense wasted no time in grilling her on her previous statements where she allegedly said that if her husband ever cheated on her, she would do away with him. But we just witnessed how she was able to handle that, and the prosecution was able to redirect her. She just didn't remember making that statement. After her emotional testimony, the jury also heard from several investigators and crime scene experts reconstructing the crime scene virtually and through video for these jurors. It was really showing the carnage of the murders that day, and the jurors had to watch multiple graphic videos. It was eerily quiet inside the courtroom during much of the crime scene video, but the family members in the gallery were clearly upset during this time, and the emotions, Julie, poured outside of the courtroom into the hallway during a break. One woman was crying so uncontrollably she started to hyperventilate. It's just very heavy and emotional inside this courtroom.
I can imagine, Chandler, just looking at that video, and we can't even show the worst of it. We can't show what that scene looked like in its entirety, just those little pieces that we were showing a moment ago. Just a dreadful, painful crime scene, and that just rocked this small town. As far as how the case is progressing, could you talk to us about where we are in the state's case, how things are looking for tomorrow, and if we may see anything presented by the defense?
Absolutely not quite yet. We're going to have another full day of prosecution witnesses in the case, including the lead case agent. This is a prosecution that has meticulously planned out its case in chief, Julie, for chronological order. So we're going to see a lot of these investigators called more than once with the permission of the judge throughout the prosecution's case in chief. So we're expecting that lead case agent tomorrow, followed by employees of RJR to take the stand, employees of the Indigo Signs business just a few yards away, where we know that the defendant allegedly, according to the prosecution, drove one of the work trucks and parked it at the Indigo Signs business. We're also expecting tomorrow to hear from more officers from the Mandan Police Department. So again, still walking this jury through the investigation and how they're going to pin it on the man we just showed right there, Chad Isaak.
Chanley Painter, thank you so much for all your reporting tonight. We will talk lots more about this case tomorrow. We'll see you then. And what I want to do now is bring back in our think tank tonight. Three excellent criminal defense attorneys are on the program. We have Renee Hill, Michael Bixon, and Eklund Mercy. Great to have you all. Let's talk a little bit about one of those clips we were playing just moments ago, where this widow was ultimately impeached, although a little bit clumsily, by defense counsel on these statements that she made in that interview. I want to ask you, and I'll start with you, please, if I may, Michael. Do you think defense counsel was able to get the point across that she said this and there may be some motivation? We know the state is lacking in motivation here, and I'm wondering if you think the mission was sort of accomplished and what he may have been trying to get at.
Sort of. I mean, there's definitely a fine line that you want to walk in front of a jury. And on one side, you could be a lot more aggressive and really attack her for, definitely making what looks like conflicting statements here. But on the other hand, do you really want to attack a widow on the stand? Now, I think what they're trying to do here is obviously they've brought light to the fact that they think that there is some shoddiness to the investigation. And if they are able to combine that with the fact that maybe there were some other suspects out there, I think that's going to look very good in front of a jury. But again, I think they just have to be very careful about how they do it. And that includes attacking a widow of one of the deceased. And so you just have to be very, very careful. But yeah, I do think there was some room where they could have maybe a little bit more assertive or aggressive in the way that they were questioning her.
Sure. Appreciate that, Michael. I agree. Renee, let me go to you next on this one, please. With the way we know these facts have been laid out by the state, we saw it was almost like they laid out a pretty succinct open, focusing a lot on the what happened, but really not on the why and who else. And it seemed like, yesterday we saw defense counsel, really just impressed a lot of people with a very meticulous opening statement and talking about how this investigation didn't go through so many people who may have had motivation to commit this crime, and that his client is lacking any motivation or any real connection. Talk to me, please, Renee, about how you would fashion a case if you're on the defense side. I know there's no obligation whatsoever to put on any defense, and I always like to say that, and because that is very true. But if you do have a case like this one, I would think you might have a really good shot, and especially with a client who has no criminal history and has spent his career, literally devoting his career to helping other people.
Absolutely. And those are the things that you have to highlight to this jury. The fact that he does not have a record, the fact that he has been helping individuals in his community for such a long time. And you also have to show that although the prosecution doesn't have to prove motive here, they still have to make it make sense. And in this case, it doesn't make sense. Now, granted, there's a lot of circumstantial evidence that is not good for the defense in this case, in terms of the evidence that's been recovered from the defendant's home and from his vehicle. But putting that aside for a moment, everything else doesn't make sense. And the prosecution is going to have to prove the identity of the perpetrator beyond a reasonable doubt, just like they have to prove each and every element in this case. And so for the defense side, you want to highlight everything that is positive for the defendant about his background, and you want to highlight everything that's missing in this case for the prosecution. And that's the best way that you can go about it.
Right, absolutely. I have so many questions I want to ask you three. Unfortunately, I have to take a break right now, but our think tank's going to stay with us here on Closing Arguments tonight. I'm in for Vinnie Politan, and what we want to do is preview for you what is ahead here on Closing Arguments tonight. We've got a jam-packed show. Take a look. On the docket tonight in Atlanta, Georgia, Rayshard Brooks shot and killed by police after stealing their taser and firing towards Officer Garrett Rolfe. Tonight, we have a preview of the officer's trial.
The possible sentences for a felony murder conviction would be life without parole, or the death penalty.
Plus, Robert Durst's highly anticipated testimony is on hold until next week. Do you think his testimony will help or hurt him? We'll look at your reaction on social media when the 13th juror speaks. Welcome back. I'm Julie Grant in for Vinnie Politan tonight. On the docket tonight, we have a high-profile case out of Atlanta, Georgia, where Officer Garrett Rolfe is awaiting trial, accused of murdering Rayshard Brooks in a Wendy's parking lot. Court TV anchor Ted Rowlands has the story.
Both of your careers are definitely done because you just shot a man for no reason.
5 days after Rayshard Brooks was shot and killed by Atlanta police officer Garrett Rolfe, Paul Howard, the Fulton County District Attorney, announced an 11-count indictment against Rolfe, which includes felony murder.
The possible sentences for a felony murder conviction would be life without parole, or the death penalty.
According to District Attorney Howard, Rolfe shot Rayshard Brooks twice in the back as he was running away, with one of the bullets piercing his heart. A combination of available video, including police body cameras, shows Officer Brosnan approach Rayshard Brooks, who's asleep in his car, in an Atlanta Wendy's drive-through line just after 10:40 p.m.
What's up, my man? Hey, come in. Hey.
Officer Brosnan wakes Brooks up and asks him to move his car to a parking spot. A few minutes later, Officer Rolfe is on the scene, starting to question Brooks.
Your Honor, I just got something to eat. I went to visit my mother's gravesite. I'm not causing any problems.
Brooks is given a breathalyzer.
Just take a deep breath in, put your mouth over the mouthpiece, go as hard as you can until you stop. Blah, 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 stop.
The officers then give Brooks a number of other field sobriety tests, and at this point, Brooks is doing everything he's told to do.
3, 4, 5.
Asking if he can just walk home.
I can walk home. I don't have to.
Why would you walk home?
I just don't want to be in violation of anybody. I can walk, my sister's house is right here.
Then everything changes when the officers decide to take Brooks into custody.
I think you've had too much to drink to be driving. Put your hands on your back for me. Here, put your hands on your back. Hey, stop fighting.
As Brooks begins to fight, there's a struggle over Officer Brosnan's taser.
You're gonna get tased!
Brooks wrestles the taser away and breaks free. Officer Rolfe gives chase with his taser in his right hand, but then, watch, he switches the taser to his left and draws his gun. Meanwhile, Brooks, while running, turns back and fires the taser he took from Brosnan at Officer Rolfe. Seconds later, Rolfe fires his handgun and Brooks falls to the ground. Brooks was taken to the hospital but died during surgery.
I have my think tank still with me tonight. Criminal defense attorneys Michael Bixon, Eklund Mercy, and Renee Hill. Eklund, I want to begin with you on this one, please. Tell me, and I want you to look at both sides of the case. What do you see as the biggest difficulties that each side is facing in this case? And also, I want to acknowledge there is no burden on the defense, as we know, but we also know that sometimes it can be very helpful to present a case. So tell me how you assess this case, please.
Well, for the defense, the difficulty is the negligence. There's negligence all over this place. It was it was heavily trafficked Wendy's parking lot. So when the officer shot in a Wendy's parking lot where people were actually there, that was negligent. He had no regard for human life at that point. And then the reason for the stop was for a drunk driving where the car is actually parked. There's no reason to chase him. There's no reason. The crime did not fit the punishment. He wasn't going to do anything. There was no fact that indicated that Rayshard Brooks was going to commit any other felonies besides go home, which you had that information. So that's going to be an issue. With regards to the prosecution's going to have a little hard time with the resisting arrest. So I'm curious to see what type of argument they're going to crop for the resisting arrest. I think that they'll be able to say that just based on the times, this was immediately after George Floyd, that, tensions are high. Black men weren't feeling safe to go, weren't feeling safe to be arrested. Freddie Gray once he was arrested, he died. Sandra Bland, she got arrested and she died. So there was a different, you have to take it from Rayshard Brooks' perspective. And I think that it's going to be a little bit hard for the prosecution to do that. But I'm really curious to see how they do that. But both sides, it's not an open and closed case. It's not. It's not.
Right. No, certainly not. We're going to keep watching this one. Michael, I want to pick your brain, please. We know that use of force is going to be a major issue, if not the biggest issue in this case. And I'm wondering, let's just say you were tasked with defending Officer Rolfe. Talk to me about what kind of an expert you might bring in to educate a jury on a taser, because we know that a taser, it is a lethal weapon. It's a less lethal weapon than a firearm, but it's still a lethal one. So tell me what you may do if you were on the defense side to establish that the officer acted appropriately.
Well, just that. One, I'd want to bring in somebody to talk about the use of force doctrine, when they're supposed to use it, how much force. I'd also want to bring in someone who could really talk about tasers and break them down, explain to a jury what they could and what they could not do. Lastly, I'd also really be focusing on the self-defense aspect of this case. And I think that's really the most crucial part of it for the defense team. If they're able to demonstrate that he used a proportionate amount of defense to what he perceived, then I think he has a good shot.
That's interesting you say that. Follow up for you. Do you think we might see that presented in affirmative defense here, a self-defense case here?
Oh, 100%. 100%.
Tell us why,
absolutely.
please, Michael.
So whenever you have any case involving where both sides were alleged to have used force, you're going to want to present some type of self-defense argument. And here in Georgia, you can present a motion prior to a trial, motion for immunity, because in Georgia, if you're able to show that you acted in self-defense, it's an affirmative defense, and the case can then, you basically win it if you're able to show that you acted in self-defense. The question was it actually self-defense? And that's where sort of the use of force comes into play, the use of the firearm versus the use of the taser. And then obviously the fact that he's a police officer plays an additional role into it. So it is a very complicated issue. But again, like I said before, I do think that he has a decent shot at it.
Michael, appreciate that. Renee, I'd like to pick your brain, if I may, please, about the high-profile nature of this case. And when you're a trial attorney thinking about everything you're up against with the jury selection and whatnot, do you think this is a case where we need a change of venue? Tell me why or why not. What would be your thoughts assessing it from that perspective, please?
Well, I don't think that you need a change of venue because it is a high-profile case and everyone knows about it. So no matter where you go, you know, you're going to have someone on the jury who has heard something about the case or viewed something about the case. So you don't need to change venue, and I don't think that a judge would actually grant that request in this case. And because it is a high-profile case, you're also, you know, you don't want to try your case in the media. So you want to try to keep things in the courtroom, maybe have a gag order if possible, so that people are not talking about what their evidence is going to be in the case. You know, there are things that you try to do, especially as defense counsel, when the media is involved to protect your client. And if it's a high-profile client, it gets even harder to do that.
Great points from you all. Thank you so much for all of that insight on this one. We're going to continue tracking it for you, of course, here at Court TV. And just to let you know, we looked at the docket, and currently there are no upcoming dates set for any motions hearings. There isn't even a trial date scheduled yet, and that is largely because we know there's been a changeover with the prosecutors. Georgia's Attorney General just announcing yesterday that he's appointed a head of a prosecutors group to oversee this case. So we can imagine that with that changeover, there would be a little bit of a delay, but we're keeping our eyes on the docket for you always. And tonight, we also have an update for you in a case that is tied closely to the Rayshard Brooks case. You might remember this one. This is the shooting death of 8-year-old Sequoia Turner. Now, more than a year after Turner was shot and killed in southwest Atlanta, this is her, authorities have charged a second suspect in her murder. The Georgia Bureau of Investigations arrested this man, 23-year-old Jerrion McKinney, on Wednesday. McKinney is charged with murder, 4 counts of aggravated assault, charged with pointing a gun at another person, and 12 gang-related offenses, all stemming from that July 4th, 2020 incident. Turner sadly was killed when shots were fired into the vehicle that she was riding in with her mom. And it happened right near the Wendy's where Rayshard Brooks had been killed less than a month earlier. Now, investigators say they believe as many as 4 people may have opened fire during that incident. But until this week's arrest, only one other person had been charged in Sequoia Turner's death. Time to step aside for a break. Next, will the testimony of Robert Durst help or hurt his defense? We will hear from you when the 13th juror speaks. That is next here on Closing Arguments.
Did not use my cell phone or charge calls to my telephone calling cards. I paid only in cash and made all telephone calls from a payphone. Further, I made no telephone calls to anyone I knew and told no one about Galveston.
I did not write this. This was written by somebody else. I never wrote this document.
Please be seated, Mr. Durst. Thank you.
Exception to the above. The DA knows that on August 30, 2001, I bought the .22 pistol in Pasadena.
Oh, that was Defendant Robert Durst earlier this week speaking in the courtroom where he is on trial for the murder of his best friend and publicist, Susan Berman. Now, he is set to speak again, this time from the witness stand. His defense team confirming with Court TV that Durst will testify in his own defense. So after 2 days of testimony and grueling cross-examination of the defense's first witness, Dr. Elizabeth Loftus, court ended early for the day. And then when trial resumes on Monday, Loftus will resume her spot on the stand for more. And then we understand Robert Durst will be the next witness called. So tonight, we're asking you, our 13th juror, will Durst's testimony help or hurt him? We begin with our comment of the day. It is from Michael. Michael, thank you for writing in. He said, quote, all he has to do is reel in one juror playing the sympathy card due to his health status, and he has at least a mistrial right there. That said, sure, get up on the stand. Jurors tend to want to hear your story. Bold move, and the state may turn him into verbal tartar, but I admire his guts if he takes the stand. Michael, thank you so much for that comment of the day. I've got my think tank still with me tonight to react to all of our 13th jurors and what they're saying. Okay, so Michael says get up there. Renee Hill, I want to go to you first, please. What do you think about Michael's comment?
I like Michael's comment, and I agree with him at this point. You know what? Why not? But I think, somebody on that jury may have some sympathy for him. And, he's been lucky in the past. He may continue to hold on to that luck throughout this trial as well. And the prosecutor, I think, should tread very lightly, very lightly. It's going to be a vigorous cross, but I don't think he should go as hard as he's going with the expert right now.
That's really smart advice, Renee. I love it. I'm with you there. And for those viewers who may not realize it, this is the second time Robert Durst is standing trial for murder. He was acquitted in Texas, had the same lawyer too, Dick DeGuerin. So thank you for that as well, Renee. Let's read another comment. This one is from DeLorean, or DeLoreen. Forgive me if I'm mispronouncing it. Thank you for writing in. So the comment reads, he probably won't be able to convince anyone. His defense team is doing everything that they can. I don't think that they really want him on the stand. Looking forward to the cross-examination. DeLoreen, thank you for that. Michael Bixon, tell me what you think about this comment, please.
I don't know how much they really think they have to lose. Whether they actually win this trial or lose the trial. Obviously, he is in very frail health. I mean, he sort of looks like the crypt keeper, and if he takes the stand, I have serious concerns about what the jury is going to think. But look, it's a gamble worth taking, I think, because he really doesn't have much to left to lose. And I do think that like we heard before, it could put the prosecutor on the defensive side, because he's really going to have to be careful about how he approaches him.
Right. Oh, absolutely. Our next comment is coming from Pam. Pam, thank you for writing in. Pam says, quote, I don't know. His frailty just might win over a juror or two. He's nowhere close to the same man they allege committed these murders. Might be hard for jurors to fully grasp that. I also wonder how all the courtroom drama and theatrics will affect the jury. Love this, especially the last part of your comment, Pam. Eklund, let me go to you on this one, please. You've had experience trying a lot of cases. All of you attorneys on the program tonight have. And I mean, this one is an anomaly, isn't it? Tell me what you think about this comment from Pam.
Oh, thank you, Pam. Besides, like Michael, he's like 100. He's 100 years old. He was born rich. He was raised rich. He has never heard the word no. He's currently in custody right now. This is like vacation. What's the other option but to stay in jail? He is out here, and he is going to use all his free time to take up the court time. So do I want him to testify? Absolutely, because it's going to be entertaining. He is an honorary old man. He did that Jinx. They're going to want the same energy in which he provided the documentary in Jinx. And I do believe if the state pushes him enough, he's going to provide it. So I cannot wait for this cross-examination.
I'm with you, Eklund. I think a lot of our viewers are with you, too. A lot of people waiting and highly anticipating this. Let's read another comment. This one's from Mary. Mary tonight saying, probably not, but if he does get acquitted, it will be because Lewin is so irritating. Mary referring to the deputy DA here. Mary, thank you for writing in. Renee, it's your turn. I'm going to go to you on this one. And many people, including myself, have felt that he is going a little too hard on some of these witnesses, especially this memory expert. Your thoughts, please.
He really is. He's pushing too hard. One thing is true, that prosecutors really don't have the opportunity to cross-examine defense witnesses a lot because they usually don't have a lot of defense witnesses to put on. So he has been waiting for 18 months to really dig into this case. He can't wait to get to Durst, and he couldn't wait to get to this witness because he's reviewed everything that she's written and every case that she's been a part of. He's going so hard, and he's going overboard, and I think it is quite irritating, and it's probably affecting the jurors the same way.
Yeah, well said. You have to know when to sit down. I always like to say it when I'm on Court TV Live on the desk. Know when to sit down. That's part of being a good trial attorney, as you all know so well. And I wish we had more time to talk about, but this hour is up. But big thank you to all of you brilliant defense attorneys on the think tank tonight. Renee Hill, Michael Bixon, Eklund Mercy. It's been a real pleasure having you. Thank you so much for joining us tonight. And what we're going to do now is squeeze in a quick commercial break. When we come back, we have lots more ahead in our next hour of closing arguments.